this recording. So I thank you everybody for joining us today. This is really exciting. I'm going to briefly introduce our two speakers. The very first one is Michael. Michael Schwartz and Jeff Scorsese are here today. Michael Schwartz devotes his practice to construction law. He represents clients from across the construction industry in all aspects of projects and construction-related issues. Michael represents clients from across Ontario in his construction law practice. He is involved in every facet of the construction industry, including strategy development, from project inception to completion. He is experienced in structuring, tendering, and contract documents related to all aspects of development. Michael's practical and time-saving advice has resolved wide-ranging issues arising from procurement and contract disputes and lien, trust, and delay claims. Michael appears frequently before various boards, tribunals, and courts, including the Ontario and Superior Courts of Justice, the Ontario Court of Appeal, and the Federal Court of Canada. Michael speaks regularly to various associations and groups on topical issues concerning the construction industry. He provides clients with timely and relative updates on court cases, decisions, and statute changes. Michael has taught construction law courses for the Ontario General Contractors Association and George Brown College since 2006. In 2017, Michael was selected by the Toronto Construction Association Nominations and Awards Committee as the winner of the 2016 TCIC Chancellor's Award of Excellence. He is also listed in the Canadian Legal Expert Directory as repeatedly recommended lawyer in construction law and is recognized by Best Lawyers in Canada as a leading practitioner in construction law. Alternative dispute resolution can play a critical role in moving beyond an impasse and getting on with what is really important. Recognizing this, Michael has spent his career training to effectively mediate both as counselor and as a mediator. Our second presenter is going to be Jeff Scorsese, and he is a partner in the construction practice group at Weirfolds, with a practice that focuses on drafting and negotiating contracts and advising on other front-end aspects of construction projects. Jeff assists his clients in reviewing, drafting, and negotiating contracts and providing advice throughout the course of a project as disputes or issues arise. Jeff has experience reviewing, negotiating, and drafting all manner of construction contracts, including design build, construction management, EPC, development consulting, and supply agreements. Jeff also routinely provides strategic advice on procurement, tendering, and project structuring. His clients include public and private owners, developers, contractors, subcontractors, suppliers, and consultants. Jeff gives back to the construction industry by providing his knowledge and insight as an instructor of the Law and Construction Contracts course at the School of Construction Management and Trades, the School of Architectural Studies at George Brown College. Before joining Weirfolds, Jeff received a Bachelor of Arts, specializing in political science, from the University of Toronto in 2011. He then went on to receive his Juris Doctor from the University of Ottawa in 2014. Without further ado, I would like to hand over the screen to Michael and Jeff. Thank you very much, gentlemen. It's all yours.
Great. Thank you so much for that introduction, Lori. Jeff and I have worked together for a number of years, and one thing that's not in his bio is that he started out as a litigator and was drawn to the front-end stuff, the contract drafting, and he has impressively, really, in such a short period of time, become, if not our internal guru, one or two internal gurus when it comes to contract drafting. And so whenever I'm tasked with drafting, you're going to find me knocking on Jeff's door just to run ideas by him. And conversely, if he's being honest, he does the same with me when he wants to run a scenario by. Is it worded properly? Have you seen this come up in your litigation? So I actually really like teaming up with Jeff. And so when we came up with this presentation, one of the things that we often do and talk about is the CCDC family of documents, or the OAA, the Ontario Architects Association, and dealing with their documents. Rarely do we ever spend much more than a few minutes talking about all of those other contract documents that you might not even think of as a contract document, purchase orders and whatnot. And so when we came up with this presentation, we said, I think there's some value to talking about what happens when you're not using a CCDC. The number of times that, Jeff gets called to put something together, but I don't want it to be 30 pages. Or when I get called and say, oh, we don't have a contract. Well, you must have a contract because you're doing some work and you're expecting to get paid. Let's dissect that. And so we came up with these documents you rarely think about, and we called them the other guys because I like movies, and I was trying to come up with a movie title that sort of talks about the contract documents you rarely think about. And if you're ever wondering, and you probably weren't, but if you were ever wondering, that's where the other guys come from. Jeff, have I missed anything on our intro, or should we dive into a roadmap of what we're going to cover over this week and next week?
Yeah, no, I think that sounds good. Let's dive in.
All right, so I won't read all of these, but first what we want to spend time on is to talk about the different key documents and looking at the short form version and whether, letters of intent can or can't be a contract, and some of the other documents that are the other guys, the ones you don't think of, or when you call up and say, we don't have a contract, you may actually have a contract. Then we'll spend some time on learning how to get paid, which is kind of intuitive to any business. That's why you're in business, is to get paid and not do work for free. Or if you're going to do work for free on a pro bono basis, I think you probably want to know that going into it, that it's on a pro bono basis and not after the fact. And then we'll spend time learning how to manage the documents. We'll cover this material this week, and next week we'll take a deeper dive into some of these issues. So if you advance one slide, I'll just stop maybe and pause here. If you're talking about short form contracts or supply agreements, these are the standard clauses you need to consider. And I have seen some great contracts come in where people wittingly or unwittingly actually captured everything that really needs to go into a contract. I've also seen people who, I remember when we used to watch as a family American Idol, and Simon Cowell always had that snarky comment where people would come in and be way off pitch when they sing, and they would say, I haven't even had any lessons. And Simon would say, I can tell. Well, when people come into us and they say, I wrote it myself, we might not say it out loud, but Jeff and I are sometimes thinking, I can tell. And one of the great cheat sheets, and even though this isn't a CCDC course, CCDC, the Canadian Construction Documents, there's a great cheat sheet in almost every version of the CCDC. And if you forget about the rest of the contract and you go into that first or second page, there's a table of contents. And in that table of contents, it has a number of headings. And so even if Jeff or I are tasked with making a short form contract or looking at the back terms of a purchase order or a quotation, these are the things you want to hit. You definitely want to make sure you've got the right parties. That sounds intuitive. The number of times that we have to go and lean a project, it's strange how difficult it suddenly becomes because you haven't used the actual legal entities, or the owner that you're working for is actually some agent. I'm just picking on them, but only because they come up so often. CBRE, right, is on behalf of the owner. Well, who's your contract with? So doing a little bit of that due diligence, even spending, I might be way off, Jeff, but I think it's like $35 to pull from the Consumer Affairs Ministry, and you can get a full out and find out, well, who is 1397642 Ontario Limited? Or who is, Bob's Best Drywall? Well, is that somebody that you're dealing with? Are you dealing with Bob, or are you dealing with a corporation? So that's critical. Do you have the parties? Even if you're filling in and having us or having your lawyer create a short document, even just a plug and play. Okay, here's the parties. Price is fundamental. You see that in cases whether it's breach of contract, construction lien claims. Whether it's a tendering course, right, that I'm teaching, you'll see all those cases say price is fundamental. It doesn't have to be a fixed price. It just has to have some certainty. And what do I mean by certainty? That certainty has to be, how do you calculate the price? If it's time and materials, is it unit prices? Is it a mixture of a number of things? Is it a fixed price? Just somehow to log in what the price is. Of course, you a CC form of standardized, industrialized contract. They rarely talk about the scope of work. In fact, I'd say 99.999% of the time, they're not going to talk about the scope of work other than they'll define it as the work. The contract time, when are you starting? When are you finishing? Or when do you hope to start? Contingent on a few things. Owner getting a permit. When are you ending, or when are you expected to end, or what is the contract time? So having that duration, or maybe it is open-ended. Unlikely, but maybe it is. What are the contract documents? Even when you use a CCDC, are you pulling in your quote? Are you pulling in the instructions to tenderers? Are you pulling in some other document? We're going to talk about the prime contract in a little while. Is that a contract document? Because you can still short form your contract and reference other documents. The documents probably relate to some drawings that people never think, oh, that's part of the contract. We don't have a contract, but we have these drawings. How are you going to deal with changes? Do they have to be formal? Can it just be a general nod on a random handshake on an idle Tuesday afternoon over the hood of a truck? Whatever the changes are going to be, you got to include those. Do you have warranties? Are there indemnification? Sometimes not that important on a short form contract. Exclusions are huge. Here's the price I'm giving you, but it excludes winter conditions. It excludes permits. It excludes whatever the exclusions are. You want to see if you have that in there. Do you have limitations of liability or waivers of certain types of damages? You got to put that in. Do you have waivers at large? What kind of insurance? Maybe the insurance can be in its own separate document. That wouldn't be so offside. The CCDC actually decided to rip out all the insurance stuff and say, hey, here's the general conditions about insurance, but go to CCDC 41 if you wanted to have the details. You can do that, or it can just be a one-liner that you're carrying this insurance. Do you want to include dispute resolution? It is so easy to pop champagne corks that you've got a project underway. But what happens if you hit a hiccup? And how are you going to deal with it? Maybe you want to put a portion in there. And how do you terminate? Anybody can terminate a contract. Well, I shouldn't say anybody. Anybody can. Can you do it properly? But putting in a termination clause, you might even want to put a termination for non-default. Or if you are being foisted with a termination for non-default, sometimes called a termination for convenience, you want to make sure, are you pushing that down into your short form contracts, your purchase orders, your whatever the document's going to be called, a letter of intent. So these are the standard clauses to consider. If you don't have a CCDC and want to rip that out, when you get a copy of this presentation, maybe you want to print out just this one slide and post it on the bulletin board and use it as your checklist. Have I hit all of these things when I have a tailor-made contract, when I have a short form contract? You might even want to pull out your standard PO or quote, and when you flip it over, have I captured all of these things? Do I need to add some things to it? So this might be, not just because I'm doing the talking, but this might be the most important slide that you have today, because you can use this one as your reference sheet. Thoughts on that, Jeff, before I turn over the steering wheel to you?
No, I think that was a good overview of all these key terms. I think
I know it was.
Pat yourself on the back. All right. So with that said, we wanted to kind of dive into some key things to think about when you're drafting or putting together or negotiating short form contracts or supply agreements. So again, as Mike said, these are, contracts that are probably not the size of a, full-blown CCDC, perhaps for smaller scopes. These are some of the key things to think about. So one issue that we run into a lot is the signing of your proposal or quote, assuming you're the one giving the proposal or quote. So, if you've decided that there isn't an actual subcontract or a contract in place for whatever reason, and you're just going to proceed on the basis of a quote or your proposal, you really should be getting it signed back and acknowledged by your client. We recommend including language in your quote or proposal that clearly says that, that sign and return this. And by signing and returning this, you're, acknowledging, giving us authority to proceed. And beyond that, we usually recommend including language that the terms of your proposal govern over any client-issued purchase orders or terms and conditions after the fact, and that you're not bound by any of those unless you sign them back and acknowledge them. Because a lot of times what we see sometimes is a party will give a contractor or give an owner a proposal or a quote or an estimate, and then the owner or the contractor says, yep, we're happy with that, please proceed. Maybe they even sign it, and then a week, 2 weeks, or a month later, they, maybe the project manager or their accounting team issues a purchase order, and that purchase order has a bunch of terms and conditions on it, and they send that to you and say, oh, please sign this back. That could create a huge problem from a contract perspective, because you already were proceeding on the basis of your proposal or quote. So including language from the start around that can be useful, and just having the discussion up front. Look, are there any other terms and conditions? Because if not, we're just proceeding on the basis of our quote.
And maybe just while you're on that point, Jeff, if I can interrupt. Yep. It's so easy to get lost in the hustle of a busy office, a busy life, combining both of those. And if you've taken the care to write out a quote and say, these are the terms that govern, they can't be amended without a formal written notice doing so, and then 2 months later, you get corporate from the owner or from GC saying, oh, here's our purchase order in relation to your quote. And in it says these terms govern, and just in the hustle of everything, you sign it because you're well underway. I'm not going to say it undermines everything forever or that it's a fatal flaw, but it can be a challenge. And when I say it can be a challenge, I remember when I was getting married so long ago, our chef refused to say it couldn't be done. He said, when you ask your guest, do you want a medium rare steak, a rare steak, a medium well, or a well done? He said it's a challenge to turn a well done steak into a medium rare steak. And I love the optimism that he refused to say it couldn't be done. But I also understood what he meant was you're in a world of trouble. And so I won't go as far as that chef. There are things in conduct you can point to after, but getting that signature, number one, as a litigator, if you can't get that signature, getting an email, getting a text message, something in writing saying, no, I haven't had the time to sign it, but we're all good. I'll take that over not having any communication that it's accepted. And number two, to Jeff's point, you gotta slow down for a couple minutes and just review what their standardized purchase order says so that it doesn't undo everything Jeff just set up for you to be in a good spot in the first place.
Yeah, that's right. And, a related point is this idea of, if there is a contract, so let's say, your client has issued a contract to you or vice versa, and, I know we both have seen this a lot, is your proposal or quote actually incorporated into the contract? And this can be very important because we've seen a lot of cases where, folks often think, well, we had this proposal, it was negotiated a bit with the client, and I had a page at the end with all these various exclusions in it, which were all important and all very and key to developing my price. But if your proposal doesn't actually get incorporated into the contract, right? If it's not included as a contract document, then that's a serious problem, and all of those exclusions may not be of any use. So you just always want to make sure, if you are signing a contract, does your proposal or quote need to be included in it? And if so, that you're having that discussion and making sure it gets added.
Insist on it. Really, you've got to insist on it. This may sound harsh, and I look at it from the litigation lens, and this isn't a litigation scenario, but you do need the crystal ball of what you got into. But there's a case, and there's a few cases that have picked that up, where the judge has said, my job here isn't to enforce the terms you wish you entered into. My job here is to enforce the terms you did enter into. And so by undoing everything Jeff or I have put together for you by signing off on that purchase order, there's a real scenario that a judge says, you're in business, you are sophisticated, you put your mind to putting together a quote, you executed this, either you didn't read it, which is shame on you, or you did read it and accepted it, which is shame on you. And so the consequences might be harsh, but that's what the court's there to do, is to enforce what you did actually enter into, not what you intended or wish you entered into.
Yeah, that's right. And another point I'll make is, sometimes you can't incorporate your proposal or quote into the contract. Like sometimes, the RFP or the tender documentation will explicitly say that, look, this is the contract that's going to be used if we pick you, and no contract or documentation is going to get added to the contract. So make sure you're always reading, if you're responding to an RFP or an RFQ, make sure you want to be aware of that, because you don't want to be submitting your proposal and have it significantly qualified with all these qualifications and provisos and terms and conditions and exclusions, when it clearly says in the RFP that this is the contract and there's no proposal is going to get attached to it. So you just want to know upfront as well if you can't do that.
If you're in the sales side of your company, if you are in the contract management side of your company, get a second set of eyes just to double check and say, does this work? Have we just undermined ourselves? Did we just take our legs out from underneath us? Get a second set of eyes internally, whether you have a lawyer, whether you have a president or a VP someplace, just to say, I think we're okay, but what are your thoughts on this?
Yeah. And our third point there is around formatting. It may sound a little trite, but this, it is useful. I do a lot of work with some kind of smaller to mid-sized subcontractors and contractors and project managers. And a lot of the questions I'm always getting is, okay, I need a really short form PO with very short form terms and conditions. I don't want this to look large. I don't want to scare off clients and this sort of thing. So all of which is to say there's a lot you can do. You can, if you want just a really short form purchase order with, terms and conditions, say for much lower risk scopes or, smaller value engagements, just having one page of some key terms and conditions really makes all the difference between having nothing. And you can also get very creative in terms of the formatting. So, you can always think about font size, like back in school when you had a 10 page limit on your essay. You can shrink the font size, but also the document structure. For a lot of purchase order terms and conditions, I'll sometimes use that newspaper formatting where it's kind of 2 columns, so you can have terms and conditions on the left side and the right side. That sometimes is a little more looks a little more appealing than kind of 9-sized font scrawled across the entire length of the page or width of the page, as well as schedules and appendices. Or you can kind of structure your document so it's a little more user-friendly and dynamic. So often one thing I like to do is have all the interactive fields, so the key commercial terms, right? The price, the name of the parties, project location, address information, lists of the drawings and specifications. I have that just put on a chart right at the beginning, right on the first page. And then you have a second page of, in smaller font, just standard terms and conditions around all those topics Mike's covered at the beginning. And you can do that in one page. And, there you have it. You have a 2-page document. And as I said, that's not going to be appropriate for larger scale engagements, larger risk undertakings. But for something small, that's, you can do a lot of risk management there with a short document like that. incorporate terms and conditions via hyperlink as well. I mean, that's something you can try to get creative with. We've seen a lot more of that recently. So, a lot of larger organizations and institutions, they'll say, in the RFP or in their kind of the beginning of their agreement, they'll say, oh, by the way, see this link here to our company's standard terms and conditions, and you click through it and you go to that, and they'll usually say the terms and conditions are incorporated by reference. You can get creative there, but just be careful about that, because so many times these hyperlinks get stale and they don't work anymore, so you obviously want to make sure it's always active and working. But you also just want to be careful about that. If you're going to do that, you may want to get some professional advice around it, just because the laws developing around this area. There was recently a case involving Uber, actually, where they had an arbitration provision in their company's standard terms and conditions, which they incorporated by reference into all their contracts. And the court actually ruled that that was invalid. It was ineffective and didn't form part of the contract. So that's, we don't have time to dive into the weeds on that, but that's just, you do just want to be careful there if you're just going to try and rely on, hyperlinking to documents on a website. And then as well for subcontracts, right? So, if, I don't know how many of you are, may have your own subcontractor or your own supplier directly, but for those, a lot of the same considerations apply that we've talked about, but there's a few additional considerations as well. So the prime contract is, of course, important to think about. So that's, of course, your contract with your client. And you have to kind of decide if I'm going to have a subcontract, even if it's a purchase order with terms and conditions, is that going to get flowed down to my sub? And if so, then you need to do that carefully. So you want to make sure that's properly referenced in your subcontract document, that you're very clear that it's incorporated by reference. They're assuming those obligations in your prime contract. You also want to make sure you provide it to them. The courts, especially in Ontario and in Canada, have been pretty strict around this, that, if you don't give the prime contract, if the subcontractor never sees it, just never given it, then you're going to have a very hard uphill battle trying to argue that they're bound to it, regardless of what your contract says. Mike, anything to add on that, on the prime contract?
Maybe two quick things. Number one, if you're the contractor and you don't want to share that subcontract, just right, you're going to have a bit of difficulty saying you're bound by those terms if you didn't make it available. So two things. One, if there's sensitive information you don't want to share, you're not comfortable sharing, you don't want to share with your subcontractor that you've pinched them for an $8,000 subcontract while they're making $10 million on the project, I get it. Redact out the price. Like, the price doesn't impact what is needed. If you don't want to share who some of the sub-trades are, redact that out. Just keep the key elements there so that they have it. That's my first point, is you don't have to just share it wholesale. You've got to share it. Just take out the parts that are commercially sensitive. I can live with that, number one. Number two, I'll subdivide it into contractors and subcontractors. As a contractor, share the document. So my first is, here's a copy of the prime contract. You are bound by the prime contract. If we have something in our agreement that offends something in the prime contract prevails. Here it is. Or here's a hyperlink to it. Good. Next best, available upon request. At least then, if we have to go off and argue and say, well, we said they were bound by it. Commercially, it's this thick. And if it's 4.5 inches thick, I'm not just going to provide it. I gave them the opportunity in bold, available upon request. Number three, if they request it, give it. At least I could go off to court and say, well, they knew that they were bound by the prime contract and they never asked for it. You might get a stern wagging of a finger from a judge, but that may not just, solidify or sink you. As a subcontractor, if you see that, ask for it and ask and ask and ask again. Well, maybe not too many times, but ask for it, follow up and say, I'm bound by it, I'm entitled to it. If they don't give it, then maybe you're not bound by those harsh terms that you might find in a prime contract. And what could you find lurking there? One quick example off the top of my head: liquidated damages. For every day you're late, it's $10,000 a day up to a maximum of $500,000. Well, if you're a subcontractor signing a contract for $5,000 or $10,000, one day late, you just worked for free. And remember what I said from the outset. If you're going to work pro bono, you want to know that you're working pro bono on the outset, not discover it after the fact when you're out of pocket. So those are maybe just my two quick additions, Jeff, on subcontractors and prime contracts.
Yeah, and I'll just add a third point that just came to me on from the subcontractor perspective is if you weren't given the prime contract, or if you're given it after the fact. I've seen this a lot where the subcontractor is awarded, the general contractor selects them, or it's a supplier selects them and then says, yep, we're happy with your price. Oh, again, 2 weeks, 3 weeks later, oh, here's the prime contract. That's, don't just ignore it, right? If they're trying to hook you to the prime contract, but you didn't get it, you weren't provided with it at the time when you prepared your price, that's something you really obviously want to think about and raise with them and use to your advantage in negotiating. That, look, if we, using Mike's example, if we knew there was, $5,000 a day of liquidated damages in this prime contract, we wouldn't have bid on this job, or we would have included a really significant contingency for a risk in our price. So just keep that in mind if you weren't actually given it at the time. Okay, so now we also just wanted to quickly talk about documents that we find do come up a lot in a variety of circumstances, and these go by many names. Most commonly, letters of intent, or maybe limited notices to proceed, or maybe limited authority to proceed. They come in all sorts of names, but it's really the substance that's more important than the title. But these are, if we take just using the term letters of intent, or LOIs, these are, I'm sure some of you are familiar with them, used before the contract signed. And there's really two purposes. This is how I like to explain letters of intent to folks. There's, an LOI is either used to kind of just keep somebody engaged, keep them warm, keep them interested in the project, saying, hey, we're planning to award you the contract, and the contract's going to be coming. This is our letter of intention. We intend to award the contract to you. Versus an LOI that's actually essentially its own contract, where it's authorizing the performance of certain work or services in exchange for money. And those are two very different things. And we find, I think, Mike, you'll probably agree, that LOIs are sometimes used a little too casually, where parties are just kind of, sending over a letter, calling it an LOI, saying, sure, go ahead, get your shop drawings ready, and let's get started. Looking forward to a successful project. The contract's we'll send the contract along in a week or two. That's kind of a mess from a legal perspective. Do you have a contract, or is the contract forthcoming? And I can tell you there is a lot of case law. The courts have dealt with a lot of issues around letters of intent, because they're so prone to creating these kind of murky situations where it's unclear, is there actual legal relationship here, or was this just a non-binding LOI? So I think the first point of advice really is a recommendation, a thing to keep in mind is, when it comes to LOIs, just try to be as clear as possible. Is this a non-binding LOI, or is it actually authorization to start doing work? And if it is authorization to start doing work, you want to be clear on what that is. You're just authorized to do this work for this amount of money, and the actual full contract for the full performance of the work is yet to come, right? That's kind of how you would want to structure it if it's just a mere authorization to proceed. The other thing, another way to do it is, and we see a lot of these nowadays too, especially with kind of progressive contracting models, is Just reframing it more as like a preliminary works agreement, or maybe we see that on construction management jobs, sometimes they'll be called a pre-construction services agreement, or just a preliminary works agreement, preliminary services agreement. Again, it's just setting out a really basic scope and saying, you're authorized to go do this while we get the contract in place, and you're authorized to spend up to, or incur X amount of costs, and you can't go above that without getting, further approval or agreement from us. And then lastly, the other thing you just want to always think about when you're using LOIs or LNTPs is the relationship with the main contract. And again, the courts have weighed in a lot on this. And so you want to think about, is the actual contract, is your full legal relationship really conditional on the future execution and negotiation of the actual contract? And again, when I'm drafting LOIs or LOI templates for clients, I make this very explicit, right? That, I, say in the LOI itself for clarity, this is not, this is non-binding, and it's not itself a promise or, a guarantee to enter into a contract. That contract is going to be forthcoming, and we'll negotiate and sign that when it comes along, right? So just really being clear. And then also, when it comes to the actual contract itself, if some preliminary works were done under an LOI or an LNTP or some other document, and that now you're coming to the point of signing the contract and entering into the actual contract, you just want to make sure that the math and everything checks out, and that if any work was done under that preliminary agreement, is that work being subsumed within the main contract? Are any of the monies that were paid on account of those early works being credited to this contract price? You just want to be clear around that, and we usually recommend adding a clause or two to the main contract just to be exactly clear and acknowledge the presence of that early agreement, and that those works are being subsumed within this scope of work or not, as the case may be. Mike, anything to add on that?
Maybe two quick things. One, you said the letter of intent, what you think it is sort of a comfort letter almost, to say, yeah, we've got a relationship here that's bubbling. It's hard sometimes to know what the letter of intent is meant or intended to do, because I think sometimes a letter of intent is meant to suck and blow, right? We want to keep this relationship warm, but we might stick it to you in a heartbeat and go with a cheaper price, but we want to be able to use this as, oh, it is the contract or it isn't the contract. So it's really tough to read a letter of intent and read it with a scrupulous eye to seeing what really is intent, number one. And sometimes the LOI and the limited notice to proceed are combined, right? One of my earlier cases that I still use when we do a longer version of contract courses is I use it as an example. I change the names, the dates, anything that would be identifying. But in it, it says, this letter of intent shows our intention to enter into a contract. Well, number one, that language right there tells me that that's a promise to promise. And you can't promise to promise. A promise to agree is not an agreement. That's number one. But then it did go and said, this letter further authorizes you to mock-up drawings or preliminary drawings up to permit stage. And it actually gave a dollar amount that didn't say this will be the cost. It said this is the upset limit. The most we'll be liable to you is for $40,000 for your work there. And so look at that. It's a nice, easier example to see how you can combine those two and what it's really intending to do. So again, take a few minutes and digest and really think, what is this LOI? Is this LOI my contract? Because I have had cases that there never was a contract. So the LOI actually spelled out what the price was, what the start date was, and the whole thing went to trial based on an LOI as the contract.
Right. Yeah, that kind of illustrates the challenge with them, for sure. Okay. Mike, purchase orders and invoices?
So I get it. POs sometimes everything just has to be documented because whatever software you're using, you require a PO. And so is that what your PO is for? Is just for your accounting software? That's fine. If you are intending it to be your contract term, then go back to that cheat sheet. Does it capture who the parties are? Does it capture the payment terms? Does it capture the scope of work? Is that your contract? Does it actually have those terms? I loved Jeff's idea of using the newspaper style and putting it into 2, maybe even 3 columns. Does it have all the terms in there? So know for yourself what your PO means if you're giving it to a supplier, for example. Or is it supposed to be your contract terms? And if it's supposed to be your contract terms, use that checklist and make sure you've got all of those different things. We made this comment earlier, but I think it's an important one. POs that are not signed back doesn't necessarily mean you don't have a contract. It is so much easier to say, my PO is set out and it creates the contractual terms. It's called a PO, but I could just as easily have called it a contract. And I've got it signed. This signifies to the court whether they're harsh terms or not so harsh terms. Your Honor, this is an easy one. These were the obligations. I set my obligations up. I was going to perform this work. I was going to supply this labor. We were installing this cabinetry. We were installing whatever the case may be. I did my end of the bargain. Payment was supposed to be 10 days or 30 days or whatever it was. Or this is the amount plus there was a bonus. Or this was an extra to the contract. They didn't live up to their end of the bargain. It's so much easier to have that signed and say, we definitely have it. If it's not signed back, but you have an email saying, consider it signed, treat it as signed, yep, looks good to me, I'll take that as my second place finisher. My third place finisher is, Jeff called me up and said it's good to go. Well, it's really hard to prove that I have a verbal agreement. So write the follow-up email, right? If they're not going to put it in writing, put it in writing doubly. You've already sent your PO. It's supposed to be your contract term. A quick little email. And nobody wants to upset the apple cart. I get it. You don't want to look like you are entering litigation by, govern yourself accordingly. You have confirmed orally on the 11th of June in our telephone discussion of 12:44 p.m. It doesn't have to be that way. Just say, hey, thanks, Jeff. I'll follow up in an email. I'm just going to copy my CO or my boss or, my secretary, my assistant, whatever. So it softens why you're sending it, and then send a quick email. Hey, Jeff, great chatting with you today. As promised, here's the email. I've copied Simon. We're good to go on that PO. Look forward to a successful project. I'll take that. At least you put it into writing. So the danger is just being completely silent, because then I have to go into a different toolbox and say, okay, here's the terms of the contract, even though it wasn't signed, Your Honor. And even though we don't have an email confirming, we don't have an emoji that confirms we have a contract. Look at the conduct. We did the work. We did it to this schedule. We followed these rules. There was a notice. We sent it to that person. They paid the first 2 invoices under that PO. The conduct proves that there was a contract. I would take that in last place. And did not finish, a disqualified, did not participate, is you've got your PO and then you've signed something different. Or you signed your PO, or you didn't sign the PO, you sent your PO, but nobody conducted themselves in accordance with the PO. That's a dog's breakfast. Invoices with terms but no contract or PO, the risks, I think we've underscored those. It just might be so difficult to prove that you have a contract. A trick question when we used to do this in person pre-pandemic is we'd ask by show of hands, what's more binding, a written contract or an oral contract, a verbal contract? And it's a trick question because they're both equally as enforceable. The trick of the question is, which is easier to prove? And clearly, having things in writing is easier to prove. Another judge has written a decision that other judges have followed, and it says, when 2 parties come before me in a trial, I believe both are trying to tell the truth, and they both believe they're telling me their version of the truth. How do I distinguish between them? How do I find one credible over the other? I do it by looking at the paper. I know nobody wants to be turned into a 14th century monk recording every 3.5 minutes of their day for something to be read 600 years from now. But spending a little bit of time and getting things in writing is going to prove a world of difference for your contracts, especially when you're using these other shorter form versions of contracts. In writing always trumps something said word of mouth, and that trumps just a general nod in some weird angle. How do I prove that Jeff nodded and that he wasn't just trying to hold back a sneeze? Anything to add to that, Jeff, before we move on to the next one?
No, I think that's good. Change orders.
Change orders and contract amendments. The importance of not doing extra work without one. Once again, I get it. I've met so many people over the last 20 years. It's just not how business is done. When you have an agreement, my word is my bond, my handshake is my bond. Until you end up having to write a statement of claim, you're really unhappy with not being paid for the work and now having to pay more money chasing money that you already earned. It is easier to put in writing that without a signed change order or without written confirmation. If you don't want to go to the expense of drafting up your own form of change order, then even just an email or a text message just setting it out. And again, you can write it before you even have the conversation, so it's ready to go. You can have a draft email ready to go that says, further to our telephone call of this morning, we're going to add an extra 2 linear feet to this, or we're going to extend this cabinetry by this, or we are going to have a display table added to it. As I told you, the cost of that is $1,000 plus HST, and adding 2 days to our schedule. Don't ask them to confirm. You just write it. If they disagree, they will follow up. People are so polite and they say, "Do you agree?" ? Then you don't know if they're toying with you because they haven't responded. Did they get it because they haven't responded? Are they thinking about it because they haven't responded? Just take the guesswork out. Just you do it and do it definitively. This is what we agreed to. See you tomorrow, right? This is what we agreed to. If you have any questions, if you want to be polite, if you have any questions, let me know. But don't end it with putting the ball in their court to confirm. Tying the change order to the terms of the contract, you do that almost implicitly when you say this will add 2 days to the contract or the schedule. But if you can tie it back to all of those terms so that the payment is still there, is the change order accurate with respect to its impact or any other things? Like, just make sure you've captured it. If we almost needed a new cheat sheet for you on change orders, is what is the scope of work? When is it going to be done? How much time is going to be extended? What is the price change, whether it's up or down, right? You're removing this, but you're adding this. Credit $500 for this, add $1,500 for this, plus HST, same payment terms as the main contract. We will be adding 5 days to our overall contract. Those are all of the great things that you can add to it. This point is one that when Jeff and I were putting this together, he hit the nail on the head, is just all the footnotes you see, because sometimes you've got a consultant who's on for the owner, and that owner gives it to the contractor, who then hands it down to you. There's all these footnotes. The devil's in the details, right? Make sure that it doesn't say something. Jeff, I think last night when we were going through this, you said it best. It's like, you waive all extra claims. This is it forever. Don't ever think about coming back to us once you sign off on here. And of course, everything's written in 12-point font, except for the very bottom where it's got 8 sentences in 6-point font, and you need to use the magnifying glass, and even then it blurs it. It's so small.
Yeah, that's right. And yeah, I've seen this a lot actually, where a consultant, I don't necessarily blame them, but a consultant who's doing the contract administration, they have their own kind of standard change order template that they just use and they recycle on all their projects. And it is important just to review it, because again, it may not be appropriate for your specific job, especially if the change order has additional carry-on implications that aren't being captured, right? There's maybe future potential schedule disruption that's being caused by this change that you're not intending to capture in the change order at that time. if that's going to be the case, you really want to make sure you're carefully reviewing the terms of the change order and calling that out and clarifying that you're reserving your rights with respect to potential future schedule relief or cost relief.
Jeff, you go into this next one. We're both respectful of the clock, and I see it's 12:51. Why don't we cover NDAs and confidentiality agreements, and then pause for the balance of our time here together, so that people can ask questions if they have any questions, or maybe we'll even just have a little bit more discourse on some of the things we've covered before we meet everybody again next week.
Yeah, no, sounds good. So we can close it off here. We didn't, we don't want to go into too much detail on NDAs, but we thought it's important to cover them at least just briefly, because there's they come up a lot, and I personally find in reviewing contracts, especially in the past couple of years, there's definitely been a higher prevalence of confidentiality requirements being built into contracts. It combined with privacy issues, and these are filtering their way into the construction industry as well. Requirements around not permitting any leaks of digital data or personal information and these sorts of things. So NDAs are important to keep in mind, and we'll just say a few points around this. The first is there's kind of two types. Of course, there's your contract itself may have a confidentiality clause in it, or there's you may have a separate confidentiality agreement or an NDA, non-disclosure agreement. But the purpose of them can be similar, and the idea is basically that both parties, or maybe it's just one way, are agreeing to that they're going to receive information from the other party and they're not going to disclose it. The thing I would just caution when you're being presented with your client's form of contract, it may have a confidentiality clause in it, is I find it was like force majeure clauses before 2019, before COVID-19, where nobody really paid attention to them. I find sometimes it's the same with confidentiality clauses. People kind of just breeze over them, don't think they're important. But they can be important because a lot of the times, if you have a limitation of liability in your contract that you're relying on, our liability is capped at 50% of our contract price, or maybe it's 100% of our contract price. Oftentimes, organizations will want to exclude breach of confidentiality from liability caps, and they'll want to basically make it so that if you inadvertently disclose any information, if there's a breach of confidentiality, you don't have the benefit of any liability cap. It's potentially unlimited liability. So they actually can present a lot of risk, unfortunately. So you just want to review them, make sure they're appropriately drafted and they're clear. Sometimes the language is far too broad, and it's basically that any information relating to the project or the work or my business constitutes confidential information, and you're going to take all efforts to protect it and not disclose it. That sort of language I see all the time, but it's way too broad and basically impossible to comply with. It really you should try to have it limited to actual information that's confidential or proprietary in nature, or marked confidential. That would be ideal. And then you also just want to make sure we've put on the screen here some of the common exclusions to confidentiality clauses to think about. So you'd normally want to look for these. Of course, if information is already in the public domain, that should be carved out from a confidentiality obligation. If you already had the information in your possession, and if the information was already developed by you, those are some of the common exclusions that we would typically want to see in a confidentiality clause. But then lastly, just from your organization's point of view, having your own kind of NDA template or confidentiality clause on your system that you can use when needed is useful. As I said, I'm seeing a lot more client contracts, prime contracts, even being added as supplementary conditions to CCDC contracts that are including really strict confidentiality requirements on the contractor, on the subcontractor. And in those cases, you just want to make sure that's properly passed down to any of your sub trades or any of your consultants, right? So it's good to have your own NDA template that you can get your subs to sign if needed, because again, you don't want to be subject to a confidentiality obligation, but your subs aren't. That kind of creates a risk gap that there could be potential exposure there. So maybe we'll, Mike, we can end there. If there's any questions, we're happy to answer them, but we're also happy to answer them
We're up against the clock, but I saw Lori is back on screen here. So if you wanted to filter any of these questions, or
Nope.
we're available.
Yep, that's awesome. If anybody does have a question, please unmute yourself, identify yourself, and ask away, and we'll go from there.
Hi, my name is Siddharth. You can call me Sid. I'm from Allwood Fine Interiors. I wanted to ask this question about back charges. Can the GC really push the back charges down our throats even if we have rejected to accept those back charges?
The answer everybody hates and why there's so many lawyer jokes said is it depends. It depends on what does your contract say. Does it permit? Did it already contemplate what the back charge is? Or is it as simple as your GC saying, "Oh, this project's late. Sid, I'm blaming you, so I'm back charging you $10,000." Can they do it? They can try to do it. Whether or not they're successful is going to be, I'd be giving them the same advice. It depends. Did you contemplate? Have you been able to prove that it was Allwood that actually caused the delay and that it wasn't somebody else, that it wasn't you? It's really hard to say in a vacuum whether or not it's one of those things that they can be rightfully back charging against you. But the first answer, or at least the first part of that answer, is going to come from what did you sign? If you didn't sign anything, what is their complaint? Is there any merit to it? What's your defense, right? Your defense might be, I'm not late. I said I would be able to start on June 1st. I said I'd actually start on a Saturday, just because I realized June 1st was a Saturday in my example. But you told me I'm not available till start tomorrow. How am I late? You robbed me of a week's worth of downtime. Or sorry, uptime.
That's right, yeah.
Thank you, Sid.
Thanks.
Are there any other questions? Okay.
Yeah, I got one. It's Jerry Cole from Coltech Quality Woodworking here.
Hey, Jerry.
How about on back charges, just to kind of jump on Sid's one there. What if you allowed $70,000 to do a stone contract as a sub trade to your work, and then they push this deadline down on you, and they say you need to have it done by this time, and the guy that you're carrying, this happened during COVID, we're still on this job, and then they give you they say, well, find another trade to do the work because you can't get this guy to do it, and they give you $120,000 back charge. And I said to them, I went to 3 different companies and showed them there's no way that stonework should be 120 grand. What do you do in that situation?
I'll start off, and you're going to roll your eyes, I know, Jerry, but it depends. What does the contract say? I need to take a look at it. But if it's during COVID and it's one of those legacy COVID projects, there might be a lot of defenses at your disposal. Number one, was the project delayed? Was it an unforeseen circumstance? Does the contract itself talk about war, pandemic, insurrection, that type of thing? Was there escalation clauses? Have they actually mitigated? There might not be a whole lot of teeth to their $120,000 back charge to the $70,000 that they had allotted for the stonework, when really what they've done behind the scenes, that they were being honest, is I think I could back charge a lot of it, but make the number really high so that when we negotiate with Jerry, we actually start from an inflated price. I mean, at the end of the day, they have to prove it, and nobody wants to get to a point where you have to go off to court. Next week, we'll talk about how to resolve some conflicts, and one of those things that you might have available to you is adjudication, which is a simpler form of of a court case that's binding for at least the duration of the project, that's meant to be able to be done quickly within 30 days. And if you don't like the answer, you're not stuck with the answer forever. If you like the answer and you're going to get paid, or that back charge is going to be refuted, at least you've got that win in your pocket. So there's a few things that might be open to you. But again, it still comes back down to the contract. And ideally, the answer isn't that, oh, this was a bad contract to sign in the first place. I'm sure there's more factual scenario to it to work around that. Sometimes you just end up with a bully contractor or a bully owner.
Thank you, Jerry.
Thanks.
Any further questions? Okay, I see people are starting to log out. I want to thank Michael and Jeff for joining us today, and that was a great presentation. Obviously, making sure you back up your conversations with something in writing is key. So thank you very much, gentlemen, for that. And we look forward to the second part next week. We'll see everybody on Monday next week.
That's excellent. Thank you so much.
Thank you very much, everybody.
Thank you.
Thanks.